In Cambridge Model United Nations, there are some committees that are a bit different from the classic ones. The International Court of Justice is one of them.
Well, we have two directors of the board, which is like a sort of chair for the other MUN committees. We have the six advocates or councils who represent one country and three the other country, which are the two filants of the case. And then we have a panel of judges, which would be about 10 to 12 judges. Councils, they propose and they bring forward their arguments for and against the reparations, and we judge, we ask questions, we try to clarify the points, and that's how the debate goes on.
The chairs of this committee told us a bit more about the International Court of Justice in itself and about the particularities of international law.
We are not here to criticize.
The ICJ is composed of 15 judges who serve on a term of 9 years. It was first instituted in the year of 1946 following the Charter of the United Nations. It deals with proceedings brought by states against other states, but it also can give advisory opinions. International law deals with or regulates, is probably a better word, the relationship between states. And that's really what we're dealing here with a relationship that has gone sour. And we are trying to amend that relationship and put the parties in a position that they would have been in if this conflict would have never occurred.
One of the judges explained to us the case that they are dealing with.
So the case that we're looking at is between the Democratic People's Republic of Congo and Uganda, and looking at the intervention order which did occur in 1999. Further on from that, we are progressing from an International Court of Justice ruling which occurred in 2005, which saw Uganda as the perpetrators of the event, and we're discussing the reparations of that to the Democratic People's Republic of Congo.
We interviewed the two opposite sides of this case, the advocates of the Democratic Republic of Congo and the advocates of Uganda.
We are teaming, three of us advocates, against the other counterpart, which is Uganda, and we are stating that we, as Congo, should have a sort of reparation which encompasses satisfaction, restitution, and also compensation.
We are trying to defend against the claims by the Democratic Republic of Congo, and then we're also asserting a counterclaim of our own in that Congo has actually violated the integrity of our diplomatic personnel and property in our embassy in Congo. And then we're also trying to defend against their claims of restitution because we believe that it will impose an undue burden on Uganda.
A monetary form of compensation, and satisfaction is more in the form of an official apology. Yeah, and restitution, with the concept of restitution, we will be debating and arguing on the fact that the material damages that have been caused to the Democratic Republic of Congo should be compensated by restituting the damages that have been caused. Yes, that's what we'll be doing.
Basically what happened is that during one of the attacks, soldiers from the Congolese army entered our embassy in a territory on Congolese territory, and that in itself already constitutes a violation to the Vienna Convention, since an embassy is considered to be an extension of the state.
We believe that Congo is continuing to assert their claims of restitution and compensation, especially restitution in full, and we've been emphasizing that actually these two claims are not mutually inclusive and they have to choose one over the other. So not only are we saying that restitution will impose an undue burden on Uganda, but for compensation, it's also a bit difficult to financially actually assess the damages that has been caused by Uganda. In contrast, for Uganda, we feel that our counterclaims are much more accessible and that we're able to accurately pinpoint the damages caused to our embassies in Congo.
The Democratic Republic of Congo can't expect damages for something which cannot be financially assessed.
What judges have to keep in mind is that in this kind of international cases, the verdict can have a very significant impact in the future relations of the two countries and the region.
So the political implications can be quite vast, because as the International Court of Justice, in a ruling there have been certain cases where we've taken, I wouldn't say precedent, but advocates have presented the importance of precedents in rulings such as Iraq versus Kuwait and other conflicts in African territories to be taken into account for this ruling. So I think one thing you have to make quite sure in making a ruling such as this is that this will be a framework for future conflicts progressing down the line, and whatever we decide here today and making this ruling can impact I guess, the outcome of future conflicts in decades to come.
came about. What we have seen in that article
This is why the judges have a lot of responsibility.